It is then on this footing that one must look at this process against the backdrop of the guidelines, which, as I have indicated with the reference to Ramakasha's judgment, requires corrections and appeals to be effected 5 days thereafter before the conference. This was, as my lady and the Lordship know, barely a few days, or in fact 1 or 2 days before the start of the conference, which was due to start on the 6th of November. So we say that because of the truncated timelines, branches were not even given at that stage of the process, given an appropriate and adequate opportunity to pursue their appeals, given that the conference was due to start in a day or two. The result was what, my lady? Was then what happened at the adoption of the credentials report, which is the last aspect of our irregularity complaint. And that, what happened is that once there were, of course, as the record shows, very many appeals which were lodged following the audit report by various branches. And I'll take my note to which branches they are at the moment. But there was some jiggling at the conference itself on the 6th and the 7th of November. There was the first credentials report prepared in advance of the conference, which appears at LD 19. But then at the conference itself, there was a one-body counting which excluded some of the people. The result of which was then an updated credentials report which appears at LD 21. But if we should approach the matter from the Baskin Evans perspective and use, for purposes of the argument, the version of the credentials report put up by the respondents appears as SZ15. It is clear that that report was adopted on the 7th of November. And if I may ask the Lord to go to that document itself, at LD 21, it's actually just the same document at page 544 of file 2.
LD 21.
Yeah. The updated credentials report, LD 21, yes.
So is that the same document that is at 1442? SZ 15?
144?
2. That's what you referred us to earlier.
Yes, that's the respondent version
Yes.
of the credentials report.
Is it the same document?
It's substantially the same, except that there is the reason why there's a difference, as I recall, is that it accounted for people who attended.
Okay, so we must refer to your report 544.
After the one body count and the exclusion of those people who were there and those who were not there. But it is for all practical purposes, it's the same document.
Okay.
So we know the complaint that the applicants made at paragraph 114 of the founding affidavit is that the credentials report, which was signed off, as we now know, on the 4th of November, was signed at a time where there were numerous outstanding queries and appeals. And the fact that these appeals were still pending when the report was signed off is confirmed by the report of the appeals committee which dealt with those appeals. You will find that the appeals committee report as SZ10, file 4 at page 1362. The report details a number of appeals, and I counted 28 wards in eThekwini region only, which are set out in the document itself. And I can name them. The start is really in relation to eThekwini municipality. These are the appeals starting from that page 1362 up to 1374, just eThekwini municipality. And I should underscore at this stage, my lady and my lord, that eThekwini ward, or the wards mentioned here, are the biggest wards in the area of KwaZulu-Natal. And if one looks at the credentials report itself, being LB21, we've counted something like plus or minus 20,000 members from various branches mentioned in this category of the branches. So it's not a small number of people whose appeal was still pending at the time that the audit was signed off. There were other appeals also which were still pending. If you look at paragraph at page 1372, relating to, in particular, the Mtuba wards in the far north region. 5 wards appeals from that area were still outstanding. They are enumerated in that report from 1372 to 1375.
Sorry, Mr. Madansela. And in the right-hand column, from pages 1362 to 1372, is a word often used, this ward was qualified.
Yes.
To understand, then those appeals were upheld.
Yes, I will deal with that, because I've extrapolated these statistics or these instances of appeals from a report which was prepared after, which obviously contains the result of those appeals. And I will deal with the results of those appeals in a moment as part of the second aspect of this of the complaint. The point being that in very many places, or in various wards in KwaZulu-Natal, the far north, eThekwini, which is the biggest region, and others, because we know that SZ10 is not a complete document. There are pages missing, pages missing. And that's besides the point. The point is that quite a number of them were still outstanding, and yet the audit was finalized. The result. How does the respondent deal with this complaint? My lord and my lady will see this at file 3 in the answering affidavit, paragraph 343.
Page?
At page 1081 to 1095, sorry. What that response consists of is a criticism about the credentials report which has been put up by the applicant, and the criticism is confined to basically saying that, well, all those documents are hearsay. But as I said at the start of this part of the argument, we are prepared to approach this case on the basis of their own credentials report. because it illustrates the irregularity. But what is fundamental about the response is that there is no dispute about the fact that the appeals and queries were still pending when the audit was finalized. Indeed, the appeals committee report, which I've already referred to, confirms this. What then happened, my lady, is that a voter's roll was then created on the strength of the audited reports from the branches. In the replying affidavit, we illustrate where the problem was with the creation of the credentials report based on an audit which was finalized at the time when the appeals and queries were still outstanding. We deal with this at pages 1599 in the replying affidavit, being a schedule which has been created to make a comparison between the credentials report put up by the respondent and the final accreditation or the voter's roll, which was then created. The outcome, or basically the punchline of that comparison, is that it illustrates that there were a number of members. You'll find that it's fine. Where's the plan? Yes. That enumerates, that document enumerates that a number of members of branches who qualified as a result of the outcomes of the appeal processes did not receive credentials for the conference, and are enumerated at page 1599 in that annexure with a number of people having been left out who qualified, and they are in Roman numeral 1 up to Roman numeral 5 or Roman 7. I exclude in the computation, for purposes of the argument, the issue relating to Ward 57 of eThekwini region, because I accept, insofar as that ward is concerned, there is a dispute of fact. But in relation to those which are enumerated in Roman numeral 2 to Roman 5 and numeral 7, there can be no contest. In fact, if my lady and my lords look at the further affidavit which has been filed by the respondents pursuant to the reply affidavit, this issue is actually not even addressed. It must be taken as having been proven to have been the case for purposes of this argument. Of course, the document over the page, it also enumerates branch members who did not qualify, yet they were also given credentials ultimately at the meeting. Again, insofar as that issue is concerned, there can be no contest. So the upshot of all this is that we make a submission to this court that on the version given by the applicants, which the respondents do not dispute and cannot dispute because documents don't lie, the irregularity relating to the accreditation of branches occurred in circumstances which amount to an irregularity. I believe that there is no authority required for the proposition that if you allow people who did not qualify or disqualify people who should have been there, it should have been accredited. is an obvious irregularity that distorts the majority of the branches, the voices of the branches. And I do not understand the respondents to be contending that that cannot be an irregularity, because it obviously is. Finally, there was at the end of the conference, during the process of voting, an incident which occurred. And that incident related to the publication of the results midstream the counting of vote. What we do know, for purposes of this exercise, is that voting at the conference took place by secret ballot. As voting normally happens in these days. And so no one would have had any knowledge of what was happening behind the voting boxes when voting was taking place. At paragraph 154 of the founding affidavit, page 100, a point is made, and I think it's not disputed, that the voting started on the 7th of November in the evening and went on until 3 o'clock in the morning of the 4th of the following day. Solomon, it started at 3 a.m. of the 4th until 9 o'clock the following day. Yes, it started on the 7th and finished on the morning of the 8th. To put it correctly.
Sorry, where do we see that?
At paragraph 154, paragraph
153.
of the founding affidavit.
15.
Well, the times are set out in 155.
Yes, the details, paragraph 155.
Yes.
But as the amendment make it clear at paragraph 154 is that before even the counting was over, in fact it was still right in the middle of the counting of vote, a tweet whilst the voting was still going on, a tweet came out at about 23 minutes past 10 in the evening and made a prediction about the result of the votes. What is significant for purposes of our argument is what it contained about the votes which were going to be amassed by one of the contenders, Mr. Senzo Mkhulu. It said that he had attained 675 votes. Of course, the answer that is given by the respondents to this at page 1104, paragraph 438, is that this was a fake tweet.
Well, they say that it wasn't entirely accurate.
But that's obviously incorrect, because numbers tell the story. Lo and behold, when the result came the following day, the numbers and the votes which were counted for Mr. Senzo Mkhulu came out 675 votes. We argue in this case that this was no happenstance. And no one, no matter how prophetic he can be, could have been able to predict the number of votes with such precision as it apparently happened in this case. So therein lies the problem with how the court is going to deal with that dispute of fact. Our submission is that the court is able in these circumstances to say that the dispute which has been created in the answering affidavit is just a fanciful dispute. It cannot be believed. It's uncredited, and it's so far-fetched that the court is entitled to reject it, exercising its robust approach. And the court should find, in relation to the result of the election, that the prediction which appeared from the
tweet
reflect, in all probability, a predetermined result of the election.
That's a very serious accusation.
It's the only inference that the court can draw, given the procedure.
You're familiar with cases like Gates versus Gates that says that where there's an imputation of potentially criminal conduct, that's not lightly inferred at the level of probability.
Yeah. But my Lord, the submissions we make at this level is that it's the only reasonable inference. How would anyone would have predicted the number of votes that Mr. Mthuni was going to get? And it happens just like that, unless there was some form of behind-the-scenes machination. That's the only compelling inference that needs to be drawn on the facts in this case. And we ask the court to be robust in this regard, and make that finding for purposes of determining the irregularity. But what makes the matters worse on this aspect is the other part of the process that took place at the conference. In the founding affidavit, we have asked, or the applicants have asked, that the respondent should produce a voter's roll which formed the basis of the voting. The typical answer which has been given is angas, siyaz, shini. It's gone lost, missing. How could it have been lost? And why can't it be found in the circumstances which happened after the announcement of the result? We ask the question rhetorically. It is a sort of document that should have been kept, as we say in Zulu, because it was the very basis on which the province was to justify itself, given what happened after the announcement of the result. And the record demonstrates that immediately after the announcement of the result, following day, there was riot in Durban. And there were memoranda given to the provincial office to dispute this very result. It was particularly in those circumstances that the voters' roll should have been kept for purposes of defending whatever case that could ensue as a result of.
The explanation is given that the person who conducted the vote on behalf of the Electoral Commission left the employment of that organization.
But the province was the custodian and the owner of that voters' roll. That is an unsatisfactory explanation. Over 2 years now since this litigation has been going on, no explanation whatsoever has been given what has happened to the voters' roll. What steps have been taken to trace that the individual and ask him what the voters' roll is in a matter of such serious contestation. The defense, my Lord, in this regard, is fanciful. And the irregularity has been proven to submit. And it is an irregularity of the highest order at this level. And if the court is with us then, that these irregularities did in fact occur as we submit the help, then the obvious results are those which have been urged to be scored by Malay family. Mr. Ngoy told me that the voting process and the entire process of the conference should be declared invalid and set aside. That is, in a nutshell, is our argument on irregularities. Unless the court has any questions on any one of them, I have no further submissions.
The timeline referred to by Museneke, DCJ in paragraph 77 of Ramakatsa.
Yes.
Can you just point me to where that appears in the papers in this application as well, please?
Yes.
For example, things such as...
May I just deal with the
things such as that audited branches are afforded 5 days.
The guideline is...
Just point me to that, please.
The guideline, my Lord will find at volume 1... No. At file 3,
Okay.
page 1113, 1113.
1113.
Yes,
Z1.
it's SZ1. You remember, my Lord, that there's been a debate about which guideline is that one. I mean, it's proper for purposes of this case to approach the matter from the version which has been provided by
Respondent's version.
by the respondents
Yes.
to avoid unnecessary
Yeah.
dispute of fact or allegations of dispute of fact. That clause appeared, my Lord, at page 1115. Where it says that following the completion of each region's audit, the National Audit Team will provide the relevant provincial secretary with a copy of the preliminary audit report. The branches will then have 5 days within which to raise queries. And I think it's been shown to me that in the answering affidavit, in fact, at page 63, so in the founding affidavit, at page 63, paragraph 87 onward, those timelines are not really in dispute. May I just probably at this juncture, Justice Kuhn indicates that this very guideline appears to have been the same guideline which was the subject matter of consideration in Ramakatsa versus...
Yeah, it's not province specific, it's for all the provinces. And what is, if you look at page 259, the Constitution of the ANC, clause, sorry, Rule 26, what is the status of this document annexed SZ1? Is this a rule? Is it a regulation? What is it?
Well, the status of the guideline has been determined in Ramakatsa by Bisanege in paragraph 79. He says the ANC's constitution, together with the audit guidelines and any other rules collectively constitute the terms of the agreement entered into by its members. Thus, the relationship between the party and its members is contractual. It is taken to be a unique contract. And after making this finding,
4 branches of the ANC in KZN want the Pietermaritzburg High Court to nullify the outcomes of the 2015 provincial conference. These are those live visuals. We are going to keep you up to date with the latest details and developments here. Stay tuned.